Amendments, and thanks. They are appropriate. First of all, one that the American Bar Association supported in 2006 that didn't make it into law. They support it again now. My office was notified. But under current law, our service members that deserve every privilege they can have under the law, they're not entitled to appeal decisions that put them in prison for life even, or death for that matter, but they're not entitled to appeal to the Supreme Court of the United States. And this amendment, after all these years and efforts of trying to make it so, would allow a service member to file a writ or an application for a writ from the Supreme Court. That has not been the case before. There are cases that are certainly deserving of being heard by the Supreme Court, but the unfairness, the way the rating system goes, the way people can be intimidated, even at the appellate level by a commander, can leave really unjust decisions in place. So this is attempting to fix that situation. Of course, the military, when you sign up, you're not entitled to freedom of speech. That's very restricted. You're not entitled to freedom of assembly. You have to assemble whenever and wherever you're ordered to do that. But this is one that shouldn't be taken away. And it leads to other things that need to be corrected in our UCMJ. The Second Amendment removes the personal information from military investigation databases if the service member is found not guilty of an allegation. The lack of direct guidance on this provision has negatively impacted innocent service members that were in the process of being railroaded, but the system caught itself, corrected it, and yet when they attempted to apply for jobs or had other things come up, boom, they got hit with what happened in the service, even though it was very unfairly. The Third Amendment prevents commanders from briefing potential jurors on pending trials. And I know that may seem strange, but it has happened. And you may not be familiar the way juries are selected in the military, but I know from personal experience, my 4 years at Fort Benning, lower commanders were requested to send recommendations. Sometimes it was 2 or 4 people per company, maybe 1 from each platoon in a company, then up from the company, then battalion would pick from those and send some up, and brigade would pick from those and send. By the time it got to the commanding general, you had some of the toughest, most redneck folks ready to hang them high and put them in jail, because in the military, the convening authority, the person that signs the order to send a charge to be tried, that's the commanding, sometimes colonel in the Army, general, admiral, but that is also the person that takes all these recommended, extremely hard-nosed folks that were nominated to be on the panel, picks from them, and that's who sits on the jury. So when you hear a jury panel in the military, this is not like a civilian panel where you come in and you have some people excused for cause. I can think of some incidences that, you know, no appellate court legitimately should have put up with, where people said, there is no way I will not find this man guilty if he uses an insanity defense. And the judge said, well, I'm going to order you not to consider it. Are you going to disobey my direct order? Oh, well, no, Judge, if you direct orders. And then they said, there is no way we'll find this man not guilty if he doesn't come testify for himself. Well, I'm going to order you, gentlemen. You know I'm the judge and I'm your superior, and I'm going to order you. You must not use that in weighing guilt or innocence that he used his Fifth Amendment. Well, okay, Judge, if you are. Anyway, they were all on the jury, and every one of them had shown cause that could not be rehabilitated. But anyway, the judge let it go because he ordered them not to consider it. That was good enough for him. So sometimes you get some situations that are grossly unfair, and at some point we need to have the highest civilian court go, come on, folks. We cut you a lot of slack because we know you need a system that's streamlined, but you still got to have some fairness here. And that's what all of these are aimed at. It also would, my Fourth Amendment would create a separate career track for military judges. As Justice Breyer recently said, you don't want the person that judges thinking of the next job. Military judges should be on a separate career track to avoid any undue influence impacting trial outcomes. Years ago, before I was in 1978, the Army, I don't know about the other services, but they had made a habit of appointing the new guys to be the defense counsel, and then when they got really good, they'd move them over into prosecution. And the commander that sent charges to be prosecuted was the one that would rate some of those people involved in the court-martial. And so that was changed, and no, you can't appoint somebody to be a defense counsel unless they have a certain minimum experience in the courtroom trying cases. And that was the case when I went in. That made it more fair, really did, but this has been a problem, and fortunately, it's not a problem all the time, but it is enough of a problem. It ought to be a separate career track, just like the defense attorneys were taken out of control of the staff judge advocate and began being rated by a separate defense system. The Fifth Amendment requires military courts to comply with the Supreme Court precedent and mandate from Ramos versus Louisiana that ordered all courts to have unanimous verdict. In the military, sometimes you'll have a panel of 15, and because a lot of them have been sent out on maneuvers or different things, you have to have a minimum of 5, but sometimes you only have 5. And it's not required the verdict be unanimous, and it ought to be when you're talking about locking somebody up for the rest of their lives. So this would bring the system into compliance with all the other things in the country when it comes to criminal law. My Sixth Amendment, the amendment requires all members of the convening authority to be removed from the rating system of a military judge. Since this is the guy that actually appoints the jurors that will sit on a given case, and actually at Fort Benning, they would sit sometimes for months until they had a verdict the commander didn't like, and then the commanding general would excuse them and appoint somebody else to be on the juries that sat on these cases. So it would help if we change that system. Number 7, that amendment ensures retroactively that members of the armed forces are not dishonorably discharged for refusing the COVID-19 vaccine. We've heard some horror cases where people have lost limbs, they've given their service, they're getting close to retirement, and because of their own physical situation, they elect not to have a vaccination, and let's face it, when basic message coming out of the administration is, we have, as the President said, we've got to protect the vaccinated from the unvaccinated by making the unvaccinated take the vaccination that does not protect the vaccinated from the unvaccinated. That's the message that's being sent out from here. And service members should not get a dishonorable discharge if they've had a very honorable service but elect not to take the vaccination. If they're going to separate them, that's one thing, but it sure shouldn't reflect that service was dishonorable when it's never been anything but honorable. So those are the 7, and would humbly submit, we really do need to make some changes here.
Thank you. Mr. Stauber.
Thank you, Mr. Chair. My first amendment is 385. In the fiscal year